Welcome to Legal 123s with ByrdAdatto. Legal issues simplified through real client stories and real-world experiences. Creating simplicity in 3, 2, 1.
Welcome back to another episode of the Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd.
Thanks, Brad. As a business and healthcare law firm, a client call is usually a request for help. But sometimes clients don't recognize they even need help, and instead it's often too late when they finally make that call. Today's story is not one of those examples.
Yay.
Rather, our client today was about to sign on the dotted line and decided at the last minute to send the agreement to us to bless it before he signed.
One of those pivotal moments for sure, Michael. You know, we can so clearly see the disaster that would have occurred in this particular story had he not paused and asked that question. Do you have any types of those moments in your career?
Yes, with a caveat, Brad. As we record, I just had a birthday, so I'm going to be really sensitive to age jokes, which you can't help.
I cannot help.
Okay, well, we'll see what we can do there. Just know that if I start crying, it's your fault.
That's fair. I'm all right with that.
Okay. So I had a moment like this when I was a summer law clerk at a big law firm in Dallas. There's this one moment where I paused to ask a question that I really believe ended up shaping the early years of my legal career. And kind of at that moment, the practice of law crystallized for me. Like all of a sudden, I got the bigger picture of what lawyers were trying to do. And it kind of went from the theory of law school into the real world. And it all made sense to me.
All right. Well, I'm curious. Tell us how it made sense.
So after my second year of law school, I had managed to hustle and leverage every relationship I knew to secure 2 summer clerkships.
So blackmail, got it.
Yeah, you can't prove that. The clerkship in the first half of the summer was the only one that had a possibility of turning into a job. The job market was super tight. This was the summer of 1994.
Did you say 1944?
Brad, we just talked about this. Pass a Kleenex. Okay, let me finish my story.
All right.
So there was 3 of us law clerks that were vying for what we believed to be one position that would be a full-time offer given at the end of the summer. We were all friends and yet all trying to get this one job. One of the clerks was the son of the firm's biggest client, and the other was a good friend from my law school. In fact, we even went to undergrad together. So to gain an edge, I showed up on the first day after orientation at 8 a.m., and we were supposed to report at 8:30. I was the second law clerk there. My buddy from my law school had showed up at 7:30, and we spent a few days trying to outdo each other and finally just reached a truce where we both would show up at 7:30 every day.
You know, and for those who don't know, compete is one of the core values for ByrdAdatto, and clearly you were already fully engaged in the compete core. So what was your pivotal moment, though? You still owe us that part.
Yes, the compete felt at the time more like survival, trying to get a job. But so during the second week of my clerkship, I was asked to prepare a motion for the partner in charge of recruiting. This was a huge opportunity because, number one, it was like getting to actually practice real law and not just do legal research. And it was for basically the guy making the decision on which of the 3 of us got the offer. Yes. And I don't even remember the specifics of what the motion was about, but, you know, in litigation, a motion is essentially something where you're asking the judge to make a certain ruling, usually over procedural matters that are going on during the pendency of a lawsuit. And so I went to the firm library.
So were there books with paper or stone still?
Yes, this was a different era. I mean, as someone in charge of renting space for a law firm, it's hard to imagine thinking that you needed to get enough space for these huge libraries to hold all these books. But that's exactly what it was. And you go into the library, you could check books out, and I found a forms book that would help me in trying to get this type of motion put together. And then eventually I found an electronic version of that I was able to use as kind of the template for preparing this motion for the partner. I plugged in the names of the parties and basically I just filled the blanks in, Brad. It was about the same quality as if someone went on LegalZoom and filled the blanks in themselves. I did not know any different and was just about to go give this to the recruiting partner.
Yeah, at this point, typically we try to ask, so Rob's not here today, so Riley is our engineer. Maybe she'd add some music where the story starts getting we know it's about to go off the rails here.
It had all the potential. Who knows? I may not even be sitting here today had I not at the last minute thought, there's some young lawyers here, young associates at this firm that have learned what it takes to do successful things like motions. And maybe I'll go and just have him take a look at it and give me a little feedback before I turn it into the partner. The associate took one look and started telling me what my motion actually needed. And I still to this day can vividly remember where I was, the name of this young associate, and him walking me through, and just really what I started feeling when I realized, oh wow, like this all starting to make sense to me. And oh wow, I was about to turn in garbage to this partner. And so I was really excited when I left at just the realization of what needed to be done. And I totally reworked my motion. I ended up taking another couple of days. It wasn't a problem with any deadline. And my motion went from 3 pages to 15 pages with exhibits attached, and ended up getting a ton of props from the hiring partner for this project, and was a major reason I ended up getting a job after law school at this firm. Footnote, they ended up giving all 3 of us job offers.
Nice. See, it pays to work hard. And so a couple follow-up questions. Number one, how many steak dinners have you bought that associate since then?
I've lost contact with him, and he probably has zero recollection of that experience.
It's interesting. I know we'll get into this in more details, but that moment in time where you hit that pause button and then the light switch goes off, like, oh God, I'm so off on this. I've never had that experience, but I'm glad that you could share your experience like that.
Yes, I'm bringing vulnerability to the legal 1, 2, 3s.
Yes, here's some more Kleenexes. Mm-hmm. All right, well, let's get into today's story about how our client's decision to hit that pause button and ask a quick email question changed things in this way, a good way for him, so we don't have to have any scary music.
So the story today, Brad, my inbox one day had an email pop up with a statement along the lines from a client of, hey, I'm about to sign this medical director agreement, but would like you to take a quick look and bless it before I sign it tomorrow morning. The email stopped me in my tracks to drop everything and open the attachment. For purposes of today's story, Brad, we'll refer to our client as Dr. Gump.
Why Dr. Gump?
Well, I just can't not go to the old movies, Brad. I pulled from the movie Forrest Gump, where Forrest seemed to fortuitously be in the right place at the right time.
Now, Michael, you often make fun of me with all my old movie references, but so far I'm so good with this one. It is one of my favorite old movie references, so I strongly approve the name selection. But for our audience that does not know, this is a movie about a gentleman named Forrest Gump, played by Tom Hanks, and he's slow-witted but very kind-hearted gentleman from Alabama. And he's basically in almost every major American story from the early 50s all the way through the 80s, fighting in Vietnam, meeting the president, playing ping pong against the Chinese. I mean, pretty fun story. But back to our story at hand, the statement to you by Dr. Gump, it's a major red flag to hear that I'm about to sign something and we know nothing. And we know that's a loaded question when we hear the word medical director agreement.
Yeah, and let me pause real fast and just acknowledge Dr. Gump is not slow-witted.
Okay. And Dr. Gump, if you're listening, Michael made me say that.
Yeah. So, yeah, we hear the word medical director agreement, and it makes me think how in Texas we talk about what it means if someone offers you a Coke. They're, in fact, offering you a soda. You may respond to someone saying, do you want a Coke? With, sure, I'll have a Pepsi.
Except in the part that no true Texan would ask for a Pepsi. But that might not be your point.
Okay, Brad, this is an acting class. But you're right. So I remember that this one, that my point is that medical director agreements are very similar to that. So if someone says they have a medical director agreement, it can mean a number of different types of healthcare arrangements.
Yeah, and I remember this story. It was for a medical spa. That would definitely be a big red flag. We did an entire episode last season called The Preventable Death to Your Practice that highlights these kind of risks. What did you do?
Well, I basically dropped everything and opened this medical director agreement, and I identified several problems in about 2 minutes.
Perfect. Okay, tell us what was one of them.
Well, the first observation was that it was called a general partnership agreement instead of a medical director agreement, and was about 7 pages long.
Red flag.
The agreement called for a partnership between Dr. Gump and a nurse practitioner-owned entity. Let's call the NP Miss Jenny.
I'm refraining to go into full Forrest Gump, last like a box of chocolate imitation mode. But Jenny is also from the movie Forrest Gump and his love interest, who is actually played by Robin Wright. Anyway, I would expect to see a document at least titled Medical Director Agreement, or even better, Management Service Agreement. I definitely would have pumped the brakes seeing a partnership agreement.
Yeah, and another observation was the length of the agreement, 7 pages, and we both know what that means.
Yeah, Miss Jenny must have printed that partnership agreement from that same book that you found your form motion back in 1994.
Fair point.
Or 1944, whatever it is.
Too soon, Brad. Birthday was just a couple days ago. There's no way it could cover all the details that would need to be covered to make sure everyone was on the same page and for it to be compliant. I mean, the agreement would require even just a dedicated space to the clinical boundaries that needed to be in place between Dr. Gump and Miss Jenny, not to mention the business side of things.
Yeah, it kind of reminds me a little bit of a Handshake Exposed, where you would think they would know what's going on because in that particular episode, it was basically an oral arrangement. In this case, it's a 7-page document, but probably didn't really accomplish what needed to be accomplished. But what else did you observe on the quick 2-minute review?
Well, Miss Jenny's entity was an LLC. And we were in California, which meant several things.
Red flag.
Yeah. First, Dr. Gump and Miss Jenny could technically co-own a medical practice in California. So I had not eliminated the possibility of being able to modify the framework to make this work. However, Miss Jenny's entity being an LLC was the red flag that you just dropped in there because LLCs are not allowed to practice medicine in California. If Miss Jenny had had a medical corporation, it could have been feasible to work with her model.
Uh-huh. So what else did you see?
Well, the crazy one was that, going back to what I said at the beginning, that it was called a general partnership agreement. And this actually opened up a host of huge issues.
Yeah, I wanted to cut you off earlier when you said that, but I wanted to hear a little more facts for our audience. But the vocabulary word of the day that everyone must hear is general partnership. It is a legal term, so this is essentially a contract formed between in a partnership between individuals or entities. But the key element here, people, is in a general partnership, all partners have unlimited personal liability. Unlimited. I hope you understand that.
That means no limit.
Exactly, Michael. You're paying attention. You get the an extra star today. Meaning a plaintiff could have sued Dr. Gump personally for 100% of the liabilities of the partnership. Did he even know what the liabilities of this partnership was?
Oh, no. I mean, it's what made it such a huge deal. I mean, what we know is that Dr. Gump said, casually, I'm going to be being asked to be the medical director agreement, and here's what I'm going to get paid. I'm not being asked to be the medical director to supervise, not we're going to form this general partnership, or I even have any idea what the assets and liabilities of this partnership are. Dr. Gump just thought he was being a nice guy, that he was going to supervise and delegate Miss Jenny to do her treatments. If he would have signed this general partnership agreement, Brad, he would have been personally liable for the 10-year real estate lease, the $200,000 laser, and all other business liabilities.
Yeah, that's a crazy story. There are massive observations here, Michael, and just in a couple minutes of the opening of this, we've already kind of hit a few of them. What did you do?
Well, I actually almost started calling and texting right when I saw the title of the document in the first 5 seconds.
Yeah.
but I went ahead and waited 2 minutes to get these observations. And then I frantically sent him an email, sent him a text, and called Dr. Gump and implored him not to sign anything until we talked.
Nothing more fun than practicing law by panic texting your clients and calling them and emailing them. If you're a client and you see your attorney doing that, just stop what you're doing, because normally we as attorneys don't panic text you, but that's a good – Michael, approve that one. So let's go to commercial, and the other side we'll have some additional discussion on what happened with Dr. Gump. And Michael, I think along with this season, I think we can bring a friend of ours on to help talk about some of these implications.
Many business owners use legal counsel as a last resort rather than as a proactive tool that can further their success. Why? For most, it's the fear of unknown legal costs. ByrdAdatto's Access Plus program makes it possible for you to get the ongoing legal assistance you need for one predictable monthly fee. That gives you unlimited phone and email access to the legal team, so you can receive feedback on legal concerns as they arise. Access Plus, a smarter, simpler way to access legal services. Find out more. Visit ByrdAdatto.com today.
Welcome back to Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd. Michael, this season, the theme is, when should I ask for help? So for this second half of the show, we are joined by our friend and colleague, Keita McRae, to help us break down today's story. Micah, please introduce Keita.
It sounded like you just called me your wife's name, which there's probably some counseling that needs to happen. Well, Keita is my office next door neighbor and a colleague at our firm. And Keita McRae graduated. She has her degrees, Brad, are going to make us feel really embarrassed about ourselves by the time we get through it. But I'm
embarrassed about you too.
Yes, you should be. University of Southern Mississippi, BA. University of Southern Mississippi, MPH. University of Mississippi School of Law, JD. University of Houston Law Center, LLM. So we have master level law degree and the LLM doctorate level for our expertise for today.
Yeah.
So Keita, we're so glad to have you. Some accolades that Keita has received. She's been recognized as National Black Lawyer Top 40 Under 40. She was a past director of the J.L. Turner Legal Association and is an awesome person. We're so glad you're here.
Hi, thanks, Bert and Michael. It's a pleasure to join you.
So, Keita, based on all the different schools that you've gone to, tell me who your football team is that you cheer for.
My football team, and if you cut my wrist right now, it would bleed purple and gold for the wonderful LSU Tigers.
I knew that would be the answer. Go Tigers. All right. Thank you, Keita. Now, as we broke down today's story, the issue really is that we have a 7-page partnership agreement that was sent by Miss Jenny to Dr. Gump. So let's start with some of the basics. What type of entities are authorized to practice medicine in California, Keita?
So the type of entities that are authorized to practice medicine in California are sole proprietorships. That would be for a physician with a current valid license issued by the Medical Board of California or the Osteopathic Medical Board of California. A professional medical partnership, but the most common entity type is the professional corporation.
Okay, and so who is allowed to own a medical practice in California?
So generally, only a physician or a group of physicians that have a current valid license can own a medical entity. However, if it's a medical corporation, California allows non-physicians to share in ownership, so long as at least 51% is owned by the licensed physician or physicians, and the other 49% of the entity may be owned by one or more allied healthcare professionals that are licensed in California in categories that include nurse practitioners and physician assistants. Unlicensed persons may not have an ownership stake in a professional medical corporation or partnership.
Well, Michael, what if the unlicensed persons really, really want to own the other 49%? Does that make a difference?
Well, it might, because they might just put their head in the sand like some of our clients and do it anyway.
But I think Keita made a great point there. It's you got to be somebody in the industry, and some reason you and I have heard enough times they think 49% non-physician. It's really, as Keita said, an allied health professional.
In California.
Yeah. So the general partnership agreement that we've talked about could have worked, I guess, in theory, right, Keita?
Yes and no. So it's true that a general partnership on 5149 could have worked from a compliance perspective, but we knew the details of what they were trying to accomplish, and Miss Jenny was to own closer to 85% of the medical practice.
Okay, that's probably bad because that's math-wise. I was never really good at it, but that's more than 49, right, Michael?
Yeah, the math doesn't work, Brad.
Okay, good. Thanks. All right. So, but the most shocking aspect of the story to me was the idea that, in this case, Dr. Gump was going to be a general partner.
Yeah. In my experience, the concerns about general partnerships is by far the personal liability aspect. So, as Brad alluded to earlier in the podcast, general partners are personally liable for the business debts and liabilities. So that means the partner's personal assets are unprotected. And I've heard, I don't have proof of this, that this can also include the kids and the dogs. Each partner is also liable for the debts incurred by the actions of the other partners. And because of this potential personal liability, I've noticed that general partnerships seems to be limited in their ability to raise money and attract investors. Finally, general partnerships can potentially be shaky because of the risk of dissolution if one partner wants to withdraw from the business or dies. So all in all, the overall structure and limited protection of general partnerships are just not worth the risk.
And, Michael, that's a phenomenal breakdown. But why is it you and I often hear CPAs love general partnerships?
Well, we'll see it in some industries, not in medical, and the idea will be to have limited partners with a general partner, and they'll have basically the people the entity or people that are taking the risk and funding a certain risk. It's often in real estate deals will be the GP of the deal, and then you have the investors that are limited partners. But in the context of a medical practice, you don't see this because of that risk, and it makes it hard for our clients to even red flag it because they've never even heard this term. I mean, our Dr. Gump saw this and forwarded it, so I'm about to sign it, and he didn't know what general partnership means. He just thought it was normal legal language for a medical director agreement.
Right. And your point is, was perfect is an audience. I didn't mean that really perfect, but I'll say well done then, was that people hear limited partnerships all the time. So they think, oh, I'm safe. They don't understand the difference between a general partner and a limited partner, which is limited partner means you're limited versus general partner, which is you have unlimited personal liability. So very good points there. So let's, for our audience that's, again, still with us, thanks for those who've made it this far. What happened to Dr. Gump?
So what we did was we ended up setting up an arrangement using the MSO model. So for those who aren't familiar with the model, the MSO model involves a business relationship between two entities, which is a medical entity generally owned by a physician, in this case, Dr. Gump, and a management services organization, or an MSO entity, which can be owned by a non-physician. So the way it works is that the medical entity enters into a management services agreement and agrees that the MSO entity will provide management and administrative services such as billing and collecting, non-medical staffing, and things of that nature in exchange for a management fee paid by the medical entity. So in other words, Dr. Gump and his medical entity would have and maintain final authority over all the clinical aspects of the model, while the MSO entity owned by Ms. Jenny would handle the administrative and management aspects of the medical entity on behalf of the medical entity.
That's awesome. And that means it works. Michael, what takeaways do you have for our theme again? When should I ask for help?
Well, you saw the title of the podcast, and we talk about the idea of fool's gold, and that's kind of where a medical director agreement fits in healthcare, because it's a term thrown out there, like using the analogy to the Coke earlier for a soda that's thrown out there, but people are comfortable with it. It's like, oh, yeah, I mean, medical director agreement, that sounds right.
Everybody signs them, Michael.
Yeah. And so they think they're good, and it just lulls them into this kind of space of, oh, well, this must be compliant because I hear that term all the time.
Yeah, and it's a great point is that because they hear it so much, they think all medical agreements are equal, and that's not the case. And for those who are listening, to be clear, as you heard, Keto we were able to build out a model which we could do a legal arrangement. In this case, we use the MSO model, but there are times in which medical director agreements do make sense if they're done properly.
And yeah, and I would just add, to go back to the Coke analogy, this general partnership agreement was definitely a Pepsi.
Because it tasted terrible. Join us next Wednesday for Med Spa Widowmaker, where we also will have a special guest joining us. Thanks again for joining us today. And remember, if you like this episode, please subscribe, make sure to give us a 5-star rating, and share with your friends.
You can also sign up for the ByrdAdatto newsletter by going to our website at ByrdAdatto.com.
ByrdAdatto is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does it establish an attorney-client relationship. Reference to any specific product or entity does not constitute an endorsement or recommendation by ByrdAdatto. The views expressed by guests are their own, and their appearance on the program does not imply an endorsement of them or any entity they represent. Please consult with an attorney on your legal issues.